Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. At this time, I'd like to pose a rhetorical question, opinions, and commentary that we provide pursuant to the First Amendment only, freedom of speech and of the press, and not based on any inside information or information that we might have other than what is in the public record. The following: might the defense raise any unreliability of or problems in the chain of custody regarding the alleged DNA on the knife sheath that the state has asserted belongs to Mr. Kohberger, which was found at the crime scene, on a motion in limine? Now, what is a motion in limine? A motion, we know, is a request for the court to render an order on something. It is an application for a court order. So whenever you see a motion for anything, motion to suppress evidence, motion to change venue, motion for a Frank's hearing, motion for alibi, this is the court being requested to enter an order regarding whatever it is that that moving party is seeking the court to do. A motion in limine. This is a pretrial motion. It seeks exclusion of specific evidence or information from the trial. Seeks to prevent the jury from hearing, seeing, knowing about. It could be information. It could be actual evidence that's been produced, because for the jury to hear, see certain things would be too prejudicial. If they were to see something that one party feels the jury should not see, it's impossible, if not virtually impossible, for the jury member to unsee, unhear what they've already seen. So in essence, what the party seeking this motion in limine to withhold some evidence or information from the jury on the grounds that it's just too prejudicial. They're seeking a court ruling prior to trial. Now let's go back and let's look at the blueprint for this case, which is Judge Stephen Hippler's trial and pretrial order that he entered on October 9th, 2024. This document, if you go to page number 2, it's really an unnumbered page, but it's page 2 of this order. You will see under section B, motions. You'll see some familiar things here. Motions on DP, that's been done and ruled upon. The discovery and the Rule 112 ICR motions, including those to suppress evidence, they've come and gone. We're just waiting for a ruling on both. Then you see motions in limine and notices under IRE 404B, 608, 609. Judge Hippler, being as organized as he has been in this case, lists specific dates certain, deadlines, when these motions in limine must be filed by both sides. That deadline is February 10th, 2025. It's coming up very quickly. Responses are due to these motions on March 3rd, 2025. So what does this mean in practical application? The defense files motions in limine on or before the deadline provided of February 10th. State does the same thing. Now the state has the defense's motion and vice versa. So both of those sides, the non-moving party, their response to the moving party's motion due March 3rd. 2 sets of responses due March 3rd, and then the reply, which is where the person who filed the original motion, they get a final say. They're supposed to be just responding to whatever is in the response. You don't go back and re-argue your entire motion again. So it's both sides file motions February 10th. Both sides file responses to the other party's motions on the 3rd of March, and then replies due by both sides as the originating party of their own motions March 17th. And then finally, we see very similar to what we just saw in the discovery and the motions to suppress hearings. Judge Hippler has said here, a hearing on these motions in limine and notices under IRE 404, 608, 609 held on April 3rd, 2025 at 9 a.m. and continue on to the following morning at 9 if necessary. Exactly the language that he said for the discovery and the suppression motions, and we know now that those hearings did commence on the 23rd in closed session. It opened up later in the day and then it commenced again. They carried over to the 24th. Same thing here. Going to be held on the 3rd of April at 9 and continuing on to the next morning, which would be the 4th at 9 if necessary. So what might we see? And again, this is just presuming that these documents are going to be public and not sealed as so many things have been sealed. But then we see also Judge Hippler last week at the hearing when the media coalition was heard. He said during that hearing, I keep seeing filings from both sides, sealing documents, stipulations to seal documents, and I have told them, he said, words to the effect of knock it off. And then it's followed up by the order of January 27th, where he has now made a commitment that he intends the transcript from that closed hearing starting at 9 o'clock on the 23rd to be made public. He's giving both sides 2 weeks, 14 days, to review it, to make a list of what they feel needs to be redacted and get it over to Judge Hippler. They've got to give reasons, however. It's not going to be rote just because you want something sealed, that it's going to be sealed. They have to, plaintiff and defense, state of Idaho and Mr. Kohberger, are going to have to give bona fide reasons. And what I would argue we should expect to see, if it's public, would be possibly some case law or some rule of procedure, as they've done when they've raised motions to seal documents in the past, and then say specifically why, in this particular case, this situation matches the legal authority that we have cited to here, and this is why this should be sealed. We haven't seen a lot of that in past filings seeking either by stipulation where the two sides agree to seal things, or it's one side or the other that wants sealed things. We've not seen where, okay, if you're going to raise the issue that someone's life might be in jeopardy, that's been an objection that's been raised. Without this information being sealed, explain how exactly, if this transcript that you want certain pages redacted from the public will lead to someone's life or safety being endangered. So returning now to the idea of a motion in limine possibly being where the defense raises some argument that the DNA evidence should be thrown out because it's unreliable, because as the defense argued by and through Ms. Taylor at open hearing, she addressed the fact that there were no policies and procedures for Othram, or there were policies and procedures that weren't followed. Othram did some of the testing in this case. So that might be, arguably, potential grounds. We have no information. The filings in this case are so sealed, so therefore the public is at some sort of a disadvantage. But if she's got facts that call into question the reliability, or that there was a break in the chain of custody of that evidence from the moment that it left Madison Mogen's bedroom to the time of testing at every point and thereafter, that might be a motion in limine to keep that evidence out of the trial. And Judge Hippler would be required to make a ruling prior to the trial on such a motion. So if they have facts that are really strong, that might be something that you might see in a motion in limine. Again, assuming that there are facts on the record that give them a good faith belief that this is a proper thing to bring before the court, have the court rule on. Another issue might be experts. Let's just say that defense raises an expert witness that they intend to call. Remember what the parties were required to produce. It's not just what they were expected to rule upon, it's what their expert or proposed experts' background, skills, knowledge, and experience, because they were supposed to produce a curriculum vitae, also known as a resume. So let's just say the state sees an expert witness proposed by the defense and says, whoa, wait a second here. This person's really not an expert in this field, or this field is irrelevant. It's not a matter that's proper in this case, or their methodology, maybe they've been thrown out before by other courts as unreliable. We're going to move to strike that expert. Now imagine if Judge Hippler gets a filing like that, and then after everybody's been given an opportunity to be heard, there would be a response from the defense, there would be a reply by the state, and then the judge would undoubtedly hold a hearing, and possibly an evidentiary hearing where the expert would be called in, sitting up on the stand, and then have to be subject to examination by both sides, and possibly even questions by the judge, to determine whether the judge should grant or not grant that motion in limine. That's another possibility that might come up in a motion in limine. Hopefully these documents will be public. If they are, they will be filed very, very soon. It could be any day, but the deadline is the 10th of February of 2025, unless the court extends that deadline for some reason or another. So in the meantime, keep your eyes monitored on the case summary page, because that's the document that tells us when filings are noted by the clerk of court. And in some cases, it might take a few days before it ever reaches the public docket. And then you can see a motion in limine filed by the state or filed by the defense. And then you're going to see if there's an agreement to stipulate to seal them, or if it's a sealed document. That's the lock and key icon that you'll see on the case summary page. Versus if it's a PDF, then that means that document's going to appear on the docket. Beginning anytime now. Today is the 28th of January. The 10th is right around the corner. So let's keep our eyes monitored. We will certainly do that. And if we see any filings, if we see the court extending this deadline for motions in limine, we will let you know. Until then, this is Kathy. If you like our content, please subscribe to the channel. Please also comment. Your comments, your thoughts, your opinions are very important. Thank you for joining us here today.